Okay, I will call this meeting of the Senate Judiciary Committee to order. Would the Secretary please take the roll?
Senator Flores,
Present.
Senator Orenshaw, Senator Lang, Senator Wynn, Senator Hansen, Senator Krasner, Senator Ellison, Chair Scheibel.
Here, please mark Senator Orenshaw absent excused. Please mark Senator Lang present when she arrives. Thank you everybody for joining us today. We have reached that point in session where senators will be in and out of our meeting to present bills in other committees, so please do not take it as a sign of disrespect if you see somebody leaving or coming to the meeting early or even on their phone checking to see if their bill is up yet in another committee. I assure you that we are all very interested in these bill presentations this afternoon. We are excited to hear again from the Attorney General's office, and I will take the bills in order unless there's any reason not to. Okay, great. Then I will open up the hearing on SB 35 and welcome our presenters down to the front of the room. I know you've been here a few times already, but there's a little button on the table to press, and when it turns red, you can start speaking, and go ahead whenever you are ready.
Thank you so much, Chair Scheibel, senators, for hearing Senate Bills 35 and Senate Bills 50 this afternoon. Teresa Benitez-Thompson, Chief of Staff to Attorney General Ford. And with me down from Las Vegas is Chief Alyssa Engler. She's in charge of our Criminal Prosecutions Division, and she's going to be presenting SB 35 and SB 50 for you.
Thank you, Chief of Staff Benitez-Thompson, and good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. My name is Alyssa Engler, and I'm the Chief Deputy Attorney General in the Criminal Prosecution Division of the Nevada Attorney General's Office. I will take this opportunity to explain the specific intent of this bill and answer any questions the committee members may have. First, I want to point out that the Attorney General's Office has primary jurisdiction to prosecute all crimes that occur within state prison, which includes the prosecution of state employees and correctional officers for corruption and crimes against inmates. For prisons to effectively serve one of their functions of rehabilitation, we must have sufficient accountability and punishment for those bad actors who seek to take advantage of the inmate population for their own personal gains. Section 1 of this bill amends NRS 212-140 to add 2 subsections related to employees, contractors, or volunteers in a prison. Specifically, subsection 2 of NRS 212-140 will now make it an e-felony to communicate with a prisoner outside the course and scope of his or her duties for prurient or illegal purposes. An example of this conduct would be letters and phone calls discussing the introduction of contraband into the prison. Subsection 3 of NRS 212-140 would now make it a Category D felony to communicate with a prisoner with the intent to arouse, appeal to, or gratify his or her own sexual desires or the desires of the prisoner. Examples include sending nude photos to an inmate, sexting, or sexual phone calls. I'll point out that we have a specific case in our office where a correctional officer had sent nude photographs of herself to an inmate that was in possession of an illegal cell phone. There were other communications via text and letters that supported the two were in a romantic relationship, but we had no physical evidence of sexual contact and no cooperating victims. So this conduct could only be charged as a misdemeanor under the current statute. Amending the statute will close the gap that has allowed inappropriate relationships between correctional officers and inmates to go largely unpunished because the factual scenarios do not fit in within the context of existing law. There is a clear danger to other inmates and correctional officers when a correctional officer or staff member is compromised. An increase in penalty will act as a deterrent. Moving to Section 2, we are changing the term intoxicating liquor to intoxicant in NRS 212-160 and defining intoxicant as a controlled substance analog, a spirituous or malt liquor or beverage, a synthetic cannabinoid, or other chemical, poison, or organic solvent. The prisons have seen a huge increase in the introduction of spice through the mail. Spice is a synthetic marijuana intended to mimic THC. These products can be purchased as sheets of paper online and sent through the mail. Current law would make it a misdemeanor to introduce these Current law makes it a misdemeanor to introduce these synthetic products into the prison. With this amendment, it will now be a gross misdemeanor. Lastly, Section 3 of this bill increases the penalties for sexual abuse of a prisoner under NRS 212-188 from a Category D felony to a Category B felony, and increases the penalty for unauthorized custodial conduct from a gross misdemeanor to a Category C felony. Thank you for the opportunity to explain the intent of this bill, and I'll now turn it over to the committee members for questions.
Thank you so much for your presentation. Do we have questions from members of the committee? Vice Chair Flores.
Thank you, Madam Chair, and thank you both for the presentation. And maybe this is something that legal can help me clarify, but I'm looking at Section 1, line 10, and then looking at Section 1, line 15. Appeal to, so line 15 says appeal to gratify his or her own sexual desires, and then line 10 says of his or her duties for prudent purposes. I'm just trying to differentiate the two. I think they both kind of fall under the same kind of intent, some type of arousal, desire, etc. And so I'm just trying to understand how we're going to distinguish, because in sub 2 we're talking of a Category E felony, and in sub 3 we're talking about a Category D. So I'm just trying to understand how to distinguish those two, and then, Madam Chair, if I may, I'll have some follow-up questions to that.
Thank you for the question, Senator. Alyssa Engler, ALISSAENGLER. Permission to go direct?
Please.
Thank you. Thank you for the question. That had actually been something that I personally looked at as well. And obviously the intent is to differentiate the two sections for subsection 3 to specifically be related to sexual desires, sexual conduct. Subsection 2 is intended to prevent the conduct related to the introduction of other types of contraband, cell phones, drugs. So clearly, if there is confusion on that language that was drafted by LCB, we can clarify that. I do want there to be a distinction between the two types of conduct.
Okay, thank you. And Madam Chair, if I might continue.
Please.
Thank you, Madam Chair. So yeah, that one was confusing for me, and I understand the intent, but I still do think that there may be a conflict just in the way I just don't know how we would differentiate between one or the other, specifically with the usage of line 10 and line 15. But that's something that we could easily work on, and maybe legal will completely disagree with me and say that that's not an issue. It'd be very easy to distinguish between the two. The second question is, I understand the concerns that were raised. Obviously, there's a huge host of issues that could arise, and you alluded to some examples of that. I was just curious to know why it is that, for example, you made the reference to an illegal cell phone or bringing in contraband, why we think that is a Category E, but then potentially nude pictures would be a Category D. I'm just trying to see the rationale and how we thought one was worse than the other.
Thank you for the question. And I would like to clarify. So there's several subsections in Section 212 that deals with the introduction of contraband. If we're talking about the introduction of Schedule 1 narcotics, if we're talking about the introduction of cell phones, those are Category B felonies already in statute. In Section 2, we have the changes where we're talking about the introduction of non-controlled substances and liquor. That is the gross misdemeanor. So hopefully that helps to clarify a little bit in relation to the furnishing of other types of contraband. So what we're doing here is, if the correctional officer or other employer or volunteer is caught furnishing the substances into the prison, that would be a category B felony. Oftentimes through our investigations, we don't actually get them to the point where they're introducing it. We want to try to be able to charge someone with a serious conduct before the contraband actually makes it to the prison. So that's what the intent of Section 1 is we have these communications that's happening. Unfortunately, there is a large number of cell phones that are getting into the prison where these communications are happening between the prisoner and the correctional officer. And we're trying to be able to punish that conduct before the contraband gets into the prisons.
Thank you, Madam Chair. And I'll hand it over, and then if I could get another round of questions at the end. Thank you, Madam Chair. Thank you for your answers.
Of course. I'll go to Senator Wynn next.
Thank you, Chair. I have a question also about Section 1. I'm thinking about some of the volunteers that we've had from, like, for example, Return Strong. There are obviously a bunch of family members that, advocate for their family members who are incarcerated and impacted by our criminal justice system, in particular our prisons. And I know that some of those, volunteers and family members have started to work even in a capacity where they may have a contract with NDOC to provide like services to help like formalize and maintain some of those working relationships. And my reading of Section 1 is in that Section 1, subsection 2, where an employee or a contractor or a volunteer for a prison who communicates with a prisoner outside of the course and scope of his or her duties would make that person a felon. So if you had like an individual who maybe had a contract, was a contractor with the prison, but was also married to like someone who is incarcerated, they would now become a felon. Is there any way to distinguish between some of those advocates and volunteers that are actively trying to work within the prison system and with NDOC officials to make sure that they are not included in that language?
Thank you, Senator Wynn, for the question. I'll direct you to the goal of Section 2, and right after, it is correct, a contractor, an employee, and volunteer, but it's communicating with them outside the course and scope of their duties for illegal purposes. So the communications that you're talking about with the volunteers or contractors, that's not going to be for illegal purposes. What we're trying to prevent here are the communications that relate to, purchasing of drugs on the outside to then bring in, or purchasing of cell phones and then bringing them in. That's the type of conduct that we're talking about. Conduct that happens outside of the prison walls. These communications are happening with correctional officers on their off-duty time, so that's the type of conduct we're trying to prevent. Certainly, if the language needs to be sharpened to make sure that that's the conduct we're trying to prevent, I'm happy to work with anyone, but the goal is to prevent the communication for the illegal purpose.
I'm glad to hear that you're willing to like look at that. Just even, a dictionary search of the word prurient, like I would worry that any kind of like romantic letters that a spouse would send would qualify under that. I understand that your intent is to go after illegal purposes and maybe ones where you're not included, but I think you run into a difficulty with some of those people that fall into that very unique, limited category as well. So thank you.
Senator Ellison.
Thank you, Madam Chair. I'm looking at the difference between B, E, D, the difference. What is actually the difference in the charge of a D versus an E? Is it like another year? Is it 6 months? Could you explain that for me? I'm going to look up these codes tonight. I just didn't have time. Could you answer that?
Yes, thank you. Thank you for the question. Alyssa Engler, for the record, I apologize. I didn't say my name in the last couple of questions. A category E felony is punished from a minimum of 1 year, a maximum of 4 years in Nevada Department of Corrections. A category E felony is mandatory probation on a first offense. A category D felony, while it has the same penalty range of a minimum of 12 months, a maximum of 48 or 4 years, they're probation eligible, but it is not mandatory.
Other questions from members of the committee? Senator Hansen.
Thanks, Madam Chair. I guess my problem I'm having with the bill is, okay, so the way this thing's worded, somebody who is a contractor employee in the prison sends pornographic pictures to an inmate somehow, or smuggles them in. You're going to put them in prison for 1 to 4 years for that kind of offense? Is there something I'm missing in this? Is there some sort of a situation in the prisons that have occurred that we need to make this really draconian type of a punishment for basically, sharing photos that may arouse somebody?
Thank you, Senator Alyssa Engler, for the record. I think we have to look at the concerning aspect of a correctional officer has job responsibilities that they are to not have these types of communications. Once you start to have these communications with inmates, they become compromised. And then while it might be pornographic photos, then it extends to phones, then it extends to drugs, then it extends to other things. They have job responsibilities. That is not to do this. And so we have to try to prevent that conduct. And we are seeing an increase. And so the example that I gave in my testimony, these weren't just nude photos. These were nude photos of the correctional officer that was text to an illegal cell phone that the correctional officer delivered to the inmate in prison. And those were nude photos of herself. And because those photos were sent, all that could be charged as is a misdemeanor, which is unlawful communication with the prisoner. So we do need to look at this, and it's not just providing a couple of nude photographs, but it's the relationship that starts developing to where there could be more serious conduct down the line.
Okay, I got it, but that isn't what the bill says. The bill says if you do these specific things, it doesn't say in tandem with a series of other actions. So that's where I got a problem. If you got a guard that's doing improper things, because I also read a little different. I've been a contractor, plumbing contractor, working in the state prison here in Carson City. And so if I went in there and for whatever reason did something stupid and gave pornographic material or whatever to an inmate with some, Puritan interests, should I go to prison for 1 to 4 years potentially, a felony? I honestly think the penalty of a misdemeanor or gross misdemeanor, which is more likely to be prosecuted anyway by a DA than a felony for something like this. On one hand, we're trying to get people out of the prison systems because we're dealing with, costs and overcrowding and so forth. Yet here for something that seems to, as I read the bill, to be a relatively stupid but not necessarily super severe crime, is going to go to prison for 1 to 4 years? I mean, to me, it just seems like the penalty seems excessive. But maybe I'm not seeing a bigger picture here.
Thank you, Senator Alyssa Engler, for the record. I'll just comment that, again, all felonies come with a prison sentence, but these sentences are probationable. So it's not that they're automatically going to prison. They are probationable eligible. And in my experience with someone who has no criminal history, the likelihood of them getting probation is very high.
Okay, well, thank you. My concern mainly is, obviously we don't want to encourage this kind of behavior, but sometimes the penalty side of it seems excessive. Thank you, Madam Chair.
Absolutely. Other questions? Yeah, please go ahead, Vice Chair Flores.
And thank you, Madam Chair, for the second bite at the apple. I did not want to hog the mic too much. And thank you for your answers. Could you, and just so that I have it abundantly clear, because I don't want to misstate anything you just stated, would you mind walking me one more time through the hypothetical of a phone with nude pictures on it being given to someone who's in the detention center, presently as the law stands, what the consequences were, and then could you walk me now what you expect to happen to that individual once this bill passes, and then I'll have a follow-up question right after that, please.
Thank you, Senator Flores. Alyssa Engler for the record. So I'll use the example that I had used about the nude photo. So if we have evidence of a correctional officer furnishing an illegal cell phone to an inmate, we can charge them with a category B felony for furnishing a telecommunication device to a state prisoner. But we have to have evidence that the cell phone was provided to the inmate by that correctional officer. Sometimes we don't have that direct linkage. We know that the cell phone got to the inmate, but we don't know necessarily how it got there. In this particular instance, when the cell phone was found on the inmate, when they did a forensic search of the phone, they found nude photographs of the correctional officer on that device. So certainly it could be inferred that this correctional officer was the one that provided that phone. But not unless we can prove that, we cannot charge the furnishing. So then what we do have is we have communication. We know that there's nude photographs that were sent, but that conduct specifically is only a misdemeanor, the unauthorized communication, because how else would the inmate have gotten a nude photograph of the correctional officer? It would have had to been sent. And it was a selfie format, so we knew that the correctional officer took that photo. So unless we can connect the phone to the correctional officer, we cannot charge that. We could only charge the misdemeanor, which is the unauthorized communication. And I hope that clarifies. If not, please ask further questions.
No,
Thank you.
and thank you, and I do appreciate your indulgence in walking me through that. I appreciate you. So then my follow-up question to that, and following the line of question that we've received from the committee today, is I think everybody in this committee room, at least from the conversations we've been engaging in, agrees with you that obviously we want to make sure that we punish the crime for what it is, and obviously bringing a cell phone in, and it's a category B felony, very severe punishment can exist for that. Now, I think I would ask that we consider engaging in further conversation on the front of an individual getting a category D felony. Again, that is presently, as we stand now, there are scenarios where unfortunately we can't go after somebody because we just can't prove all the elements of a particular crime. And I understand that's frustrating on your end, obviously, and I don't want to minimize that. But at the same time, that is just the way, unfortunately, the law works, and we believe that we are on the side of protecting rights when we approach the law through that mechanism. I would hate that because of a scenario where we couldn't go for the category B felony, and we were so frustrated by that, because it is. I understand that, and there was a lot of evidence to suggest that it was that particular individual. But I would hate that based on that scenario, we are now going to change the entire rules in the entire state of Nevada and have an individual who's being stupid and sending selfies is now looking at a category D felony for that one scenario because we couldn't go after them. We so desperately wanted to. Let's create it to where we can at least give them a D for selfies. It's difficult for me to feel comfortable with that conversation. But with that said, respectfully, I'm willing to help in any way I can to continue to work offline. But I'm still having a hard time just getting there because of that one factual scenario.
Go ahead, Senator Ellison.
Yeah, this is a little off the line, but seemed like to me, I remember reading a story just recently that they were bringing in cell phones into the prisons. The cell phones were set up for using to bring in drugs or to do a hit on somebody outside. Seems like to me if anybody's got an illegal cell phone in there, it'd be more of a violation for a big crime than it would be as, I mean the pictures are not good, but the illegal cell phone seemed like to me it'd be a big problem because, I mean, it could create a lot of problem or murder down the line. Is that correct?
Thank you, Senator Alyssa Engler. For the record, if an inmate is found in possession of a telecommunication device, it is a Category D felony under the statute, which carries that same 12 to 48-month sentence. And our statute has it as it's a non-probationable offense if you're found in possession. So we do punish the inmates if they're found in possession. And we charge the correctional officers for furnishing the cell phones if we can prove that element. What we can't punish right now sufficiently is the conduct that happens before the phone gets in, or if we can't prove that the phone has been given by that correctional officer, but we know that there's these communications going back and forth alluding to drug sales or other sexual contact. That's the type of thing we cannot adequately punish right now.
Any other questions? Okay, I also have a couple of questions. I know that we've really been focusing on Section 1, and I think I share a lot of the concerns that the rest of the committee has already expressed. I'll just point out that I think the only other place that prurient appears in the Nevada revised statutes is in the obscenity statutes. I could be wrong. I'm just going off of memory. And so what's weird about the way that this bill is structured is that you have basically obscenity and other illegal purposes in subsection 2 of section 1, but then subsection 3 is for gratifying the sexual desires of the person doing the communicating or the prisoner, which is more akin to a lewdness statute. And so I just think that it's really hard to separate obscenity and lewdness. It would make much more sense to have subsection 2 be any illegal purpose that's not sexual in nature, and then subsection 3 to be all of the sexual stuff, be it prurient interest, be it sexual gratification, be it the sexual passions and desires of the person, which is the language that we use in other statutes in Nevada. It would make much more sense to have them broken out that way. And so that's just more of a comment on section 1. I want to move to section 2 because we haven't talked about this very much. I completely understand that this statute has not been updated in a while. We want to include spice in the products that people are not allowed to introduce into the prison system. I think spirituous and malt liquor. So I do have some concerns. So in section 2, really the heart of it is in subsection 4. And we're looking at subsection B of subsection 4. I think subsection 2, because it says or, a spirituous or malt liquor or beverage would mean that they can't bring in any beverages. Because there's no qualifier on beverage there, or maybe I'm misreading it.
Thank you, Senator Scheibel. Are you asking? I'm down here, so it's hard to tell. Alyssa Engler for the record. Did you want me to answer, or are you looking to legal?
Either one.
So Alyssa Engler for the record, intoxicating liquor was what was used in the statute before, and you're correct, the statute hasn't been updated in a long time. So I think at the time when this was written, I think the biggest contraband that was coming into the prisons was liquor and cigarettes. Before cigarettes were considered contraband. What I will say is that the goal, why we continued or kept malt liquor and essentially alcohol was because that was the original intent. But certainly our goal is not to punish a Coke for the same thing as something that would cause an individual to have some sort of substance reaction to the product.
Okay, and then I'm also interested in subsection 4, just a couple lines down. I'm interested in where this language came from, and I'm not trying to hide the ball. My concern is about people who bring in something that maybe they don't know can be utilized to, have this stimulant, depressant, or hallucinogenic effect. It's unfortunate, but I think that it can happen where somebody who is incarcerated asks someone to bring something for them and they don't know that the purpose of bringing it is to then combine it with something else, remove something from it, et cetera, to create that effect. I'm just wondering whether you've seen this happen, whether you think the bill as worded adequately protects against that, or maybe you don't even mean to protect against that, and anybody who provides a substance that's ultimately utilized for this unlawful purpose is supposed to be captured by the bill.
Thank you, Chair Scheibel, for the question. Alyssa Engler for the record. So when we drafted this bill, the goal, I think what we're seeing in society is once we start to grasp one synthetic, then another one comes up and the chemical solvent changes. And so what we didn't want to do is list specific ones and then not have, I don't want to use the word catch-all, but have something to prevent the next chemical compound that comes up that is acting as a stimulant or a depressant or having a hallucinogenic effect, which is really what we're seeing with spice. It has all these things, and that's covered obviously under the synthetic and subsection C. But really that's what the intent was, is because we just don't know what the next chemical is going to be. And that's what we're hearing, is that they can vary, just a little bit. But obviously the goal is to punish those chemical poison or solvents that are used to achieve essentially what would be THC or some other Schedule I substance.
Okay, thank you. That does clarify it for me. And there's one more section of the bill, Section 3, which I also have questions about. It looks like here we're taking existing laws about sexual abuse of a prisoner, and we're just increasing the penalty, and I'm hoping you can speak to why there's a need for an increased penalty.
Thank you, Chair Scheibel, for the question. Alyssa Engler for the record. And I do appreciate you asking this question. One of the things I want to highlight is sexual abuse of a prisoner doesn't take into account consent. So consent can be the inmate can say that they're consenting to the conduct and therefore it's not sexual assault, which is the category A felony. But what we know in a prison dynamic is consent is questionable because of the power dynamic that happens between correctional officers and an inmate. So while they may say that they're consenting to it, it could be because that correctional officer or employee has a great impact on the quality of life for that inmate. And so they might feel that they have no choice but to consent. And while outwardly that looks like it's not consent, they'll tell us that it is consent. And therefore the only thing we can charge is sexual abuse of a prisoner, which is a category D felony. And I just don't think that in and of itself really punishes what's happening here with the power dynamic. A D felony does not adequately deter this type of conduct from happening. And sexual abuse of a prisoner, you have to have intercourse. Unauthorized custodial conduct, that is where you can get the groping or the other type of touching, and that's only a gross misdemeanor. And so what we're trying to do is to really say this type of conduct should not be happening, and that there is appropriate penalties to deter this type of conduct.
Thank you.
Thank you.
Yeah, I think that does answer my question. I appreciate that. And with that, unless there are other questions, happy to open it back up, but it looks like we've asked all of our questions and we certainly appreciate you taking the time to answer them. We will now move into testimony on SB 35. We'll start with testimony in support of SB 35 here in Carson City. I don't see anybody coming down to the table to give support testimony in Carson City, so we'll go to Las Vegas, where I also don't see anybody coming down to give testimony. Ms. Engler is still there. And we will go to the phones now for support testimony on SB 35.
Thank you, Chair. If you would like to testify in support of Senate Bill 35, please press star 9 to take your place in the queue. Chair, the public line is open and working. However, there are no callers wishing to testify in support at this time.
All right, then we will go to testimony in opposition to SB 35. Anybody wishing to testify in opposition is invited down to the front here in Carson City and in Las Vegas right now. I see a couple folks coming up in Carson City. You know how this works, so please go ahead when you're ready.
Good afternoon, Chair Scheibel and members of the Senate Judiciary. Clark County Public Defender's Office, Paloma Guerrero, P-A-L-O-M-A-G-U-E-R-R-E-R-O. Our opposition is with Section 1 of the bill. I understand the type of conduct that this bill is trying to prevent, but the language of the bill as written is extremely vague and overbroad. It accounts for so many different communications and actions that it would essentially make people felons for flirting. The language is not limited to nudes or communications through a phone. It's any communication with the intent to arouse, appeal to gratify his or her own sexual desires or the sexual desires of the prisoner. And sexual desires can mean so many different things to so many different people. People are in a whole spectrum of sexual desires. So it kind of leaves the prosecutor as the final arbiter of what sexual desires means. And this isn't just about corrections officers, it's about any employee of a contractor or volunteers that go into the prisons. So we would be making people felons for compliments or for falling in love. And consensual relationships can happen. So, thank you.
Good afternoon, Angela Knott from the Washoe County Public Defender's Office, A-N-G-E-L-A-K-N-O-T-T. To expand on my colleague's testimony, it should be noted that volunteers are different from a correctional officer. Correctional officers receive different training, have specific ethical codes that they must follow, and are typically in a position of power. On the other hand, volunteers can just be regular citizens with no power or authority. Volunteers can include librarians or teachers or other individuals who are volunteering their time to help prisoners rehabilitate and learn skills to better their chances of success when they are released. A volunteer is different from a correctional officer and should not be in the same category as a correctional officer. Further, SB 35 appears to make emotional interactions a felony. A simple expression of sexual interest by one adult to another may now be illegal and a felony. While I'm sure the NDOC has policies and procedures in place that prohibit such emotional interactions by their correctional officers, those should remain an employment issue and not a criminal one. Thank you.
Thank you both for your testimony. I don't see anybody else coming down to give testimony in opposition or anybody coming to give testimony in Las Vegas. So we'll go to the phones, please, for opposition testimony on SB 35.
Thank you, Chair. If you would like to testify in opposition to Senate Bill 35, please press star 9 to take your place in the queue.
Thank you, Chair and committee members. This is Nick Shepak, N-I-C-K-S-H-E-P-A-C-K. I'm a little under the weather today, so unfortunately I'm not joining you all in the building. But I wanted to say ditto to what we heard from the public defenders. As we do a lot of work with both Return Strong and Fines and Fees Justice Center with volunteers, the language around volunteering and written communication is vastly too broad as the prison system expands how it's using volunteers and outside individuals for programming and to make the system function better. There's going to be overlap. Often they won't be working in the same facility, but there will be overlap between individuals who are married, in love, or partners with incarcerated individuals. And this would be turning even just basic love letters into felonies. So we really would like to see that language tightened up. Thank you so much.
Tanya Brown, TONJA, advocate for the inmates and the innocent. We echo the concerns made by the senators, Wynn, Hansen, Flores, and Scheibel, and the previous comments made by those in opposition. But I do have a concern, or actually something that was discussed about the telephone, the cell phone with the nude photo. Let's just say, this is hypothetically, okay? What if two correctionals, male, female, are in a intimate relationship, and the female sends a picture to the male officer, and he is aware of it because he received it, and they broke up or whatever. He's retaliatory, he's vindictive, and somehow he gets his hands on the cell phone, and he brings it into the prison system just to get back, and an inmate finds it. I have a concern something like that could possibly happen, retaliatory behavior on behalf of another correctional officer, and to where a female could get into trouble. And then under Section 3A, that there's no new language in that, but I'm basing this on what I personally know to be true. It happened in Arizona, in which a female inmate and a prison guard had an affair. She became pregnant, and the child, nobody would claim the child, either side of those families, but it did wind up going to another individual raising that child. So what happens in a situation like that if the child is conceived? I don't see that discussed. Thank you. Have a good day.
Chair, the line is open and working. However, there are no further callers wishing to testify in opposition at this time.
All right, we'll go to neutral testimony. Anybody wishing to give neutral testimony is invited to do so now in person. I don't see anybody coming up to the table in Carson City or Las Vegas, so we will go to the phones for neutral testimony, please.
Thank you, Chair. If you would like to testify in neutral for Senate Bill 35, please press *9 to take your place in the queue. Chair, the line is open and working. However, there are no callers wishing to testify in neutral at this time.
All right, then that brings us to the conclusion of testimony on SB 35. Unless the presenters have any closing remarks. Okay, it looks like Ms. Engler is coming back up to the table. Please, go ahead whenever you're ready.
Thank you, Senator Scheibel. Alyssa Engler for the record. Just wanted to comment on a few of the oppositions. You know, as a society, we accept limitations on speech. We have criminalized the solicitation of a minor for prostitution, the solicitation of murder, production and dissemination of child sexual abuse, to name a few. The key is looking at whether we're limiting the time, place, and manner of this speech. This bill seeks to penalize off-duty, non-work related speech, but we must factor into the other constitutional amendment that's not being considered. We have the responsibility as a state to protect the inmate population and their 8th Amendment protection against cruel and unusual punishment. There must be a balance between both of those protections, and we believe this bill achieves that. I really appreciate the time and the thoughtful questions that the senators have given today to SB 35. Thank you.
Thank you so much. All right, we will now close the hearing on SB 35. And I will open the hearing on SB 50 and invite our presenters once again to the table. Looks like we have Ms. Engler already in Las Vegas. Please go ahead whenever you're ready.
Thank you, Chair Scheibel. Again, Alyssa Engler. I'm the Chief Deputy Attorney General for the Criminal Prosecution Division of the Nevada Attorney General's Office. I'd like to take this opportunity to explain the intent of this bill and answer any questions the committee members may have. Attorney General Ford has made consumer protection one of the guiding principles of his administration, which includes prosecuting those individuals who seek to deceive members of the public who are the most vulnerable to crimes, such as our elderly. Our office receives hundreds of complaints a year where victims have been scammed by fraudsters. It can be large sums of money or a couple $100s. In most situations, theft is an appropriate crime to charge given the facts. Under existing law, theft is not a crime or an enhancement for committing crimes against a person 60 years of age or older or against a vulnerable person applies. I believe this to be an oversight because NRS 193-167 already includes similar financial crimes such as securities fraud and obtaining money by false pretenses, and this bill seeks to amend that. Section 1 of this bill amends NRS 193-167 to add theft to the list of crimes where a sentencing enhancement can be added if the crime was committed against a person 60 years of age or older or a vulnerable person. Section 2 of this bill amends NRS 228.280 to add theft to the list of crimes where a civil penalty can be opposed. Thank you for the opportunity to explain the intent of this bill, and I'll turn it over to the committee member for questions.
All right, members, questions on SB 50. I'll start with Vice Chair Flores.
Thank you for the presentation. Quick question. Skimmers, credit card, folk that steal credit card information. I know one of the ways that they operate is they install devices on gas pumps, ATMs, et cetera, and then they steal a large amount of data, which could include, and I'm curious to know if they would be captured in some of these conversations, where you're stealing massive amount of data, but you don't specifically know who it is that you're targeting. And I am not suggesting that I am trying to create any headaches here. I'm just curious to know if there'd be enhancers in those type of scenarios.
Thank you, Senator Flores. Alyssa Engler for the record. If you obtain or use personal identifying information of another, that is a crime if you have it in your possession. It's not one of the ones that's listed in 193-167 currently.
Understood, and thank you. And I was just curious, 'cause I know sometimes there'll be individuals that goes through 3 or 4 different hands, and by the time it reaches a 3rd or 4th person, they don't even know. They weren't specifically targeting a particular person. Now, I'm not suggesting they shouldn't be held accountable. Obviously, they should be held accountable, but to the extent that they are holding information and not so much that they were targeting a particular vulnerable person or anything like that. Thank you. Appreciate your clarification.
Other questions? Yes, Senator Hansen.
Thanks, Madam Chair. Actually, for Section 1, current law, embezzlement, the only problem with the bill, and it seems like a good bill, is that the way this is structured, this is obviously a punishment after the crime has been committed. Just love it if you guys would get together. Senator Stone has a bill which actually has a level of oversight for almost this exact same scenario, but adds a step, kind of a level of oversight at the bank or credit card level to basically almost have like a co-signer before something like this could happen. So I just think you guys ought to get together, because his idea and your idea combined, you would punish it when they get away with it, but his bill would actually help prevent it from happening in the first place. So anyway, you might check with Senator Stone on that. Just want to get that comment on the record, but I think his bill and your bill together would really help minimize the amount of, I hate to say older people, because I'm only 1 year away from being 65, and that used to be really old. But anyway, people like myself and older who may be vulnerable to various scams. So thank you, Madam Chair.
Thank you. Other questions? Senator Ellison.
Thank you, ma'am. And when I read this bill, the big thing that hit me was that $650. If you're a senior in your 70s, 80s, or whatever, somebody on set income, $650 might be like $10,000 to somebody else. To me, there shouldn't be a category of 650 or whatever. It should be embezzlement is embezzlement. Fraud is fraud. You know, just like when they did, if somebody breaks in your house, they steal less than $1,000, you know, they get a ticket and then they go to court. That's crazy. To me, there shouldn't be a cap on there. Embezzlement is embezzlement. I don't care who you are, what you are. And then it says also obtaining attempt to conspiracy to obtain money, property, and value. I mean, if somebody breaks into your house or breaks into your car or whatever, $650, and then you're going to charge them. No, I think they should be charged, period. And that's me personally, because I've seen so many of these and so many thefts, and they get a dang ticket and they don't even show up for court. It's ridiculous. A crime is a crime. This ain't a crime. This is a joke in some matters. And I see it so bad all over the country and mostly in Nevada. So if you want to respond to that, thank you.
Thank you, Senator Ellison. Alyssa Engler for the record. So I'll point out in subsection 2 where we add theft, theft can be charged as a misdemeanor or a felony, depending on the loss. And to answer your question about the 650, I think when the 2019 amendments went into effect and we raised the level of dollar loss to $1,200, this statute might not have been touched because 650 used to be the threshold, which was a felony. So that just might be a reflection of the fact. But I think what section 1 was trying to do is if it's charged as a felony, then you can have the enhancement. What we're trying to do is in subsection 2, it doesn't matter if you're charged with a misdemeanor or a felony, the enhancement would apply. So if an individual loses $200 through a scam and that's only charged as a misdemeanor, then the defendant would be eligible for an enhancement of up to 6 months consecutive to the 6 months that he may get for the original theft charge. So the misdemeanor conduct in this bill with theft would cover any dollar loss.
Thank you. Other questions from members of the committee? Okay. I guess my question is very similar to Vice Chair Flores' question, because I'm likewise concerned that the crimes that are currently eligible for the enhancement, you'd have to have a pretty unique fact pattern where somebody is convicted of murder and didn't realize that they were murdering somebody who was over the age of 60. You'd have to have a pretty unique fact pattern to have somebody commit and be convicted of sexual assault with the enhancement and not realize it. But with theft, I think that there are a lot of fact patterns where you have somebody who breaks into a car and steals something valued at more than $650. You have somebody who picks up a phone, a laptop, a wallet that was left behind, and that is theft. And you have somebody who, like my colleague said, puts a credit card, skimmer or reader on the gas pump and takes somebody's credit card information. You have all of these other ways to effectuate theft that truly the person could have no idea how old the person is that they're victimizing. And so I'm wondering if it's the intention to make this wide umbrella where we're trying to discourage theft by saying, and also if you don't know how old the victim is, you could be liable for an increased penalty, or if the purpose here is to capture those fact patterns that don't necessarily fall into false pretenses, don't necessarily fall into embezzlement, but are, in fact, theft and are purposefully perpetrated against somebody who is over the age of 60.
Thank you, Chair Scheibel, for the question. Alyssa Engler for the record. I think in some of the examples that you made, larceny or auto burglary, they're not listed in here because the goal, I believe, from the intent of the statute is to punish where you're knowingly choosing your victims. And so as we know with theft, it's a specific intent crime. You have to commit the act of theft with the intent to harm that particular person. And so in these situations and all the ones that are listed, you're knowingly choosing your victims when you're committing the type of theft because you have to be intending to do so. And I think in the context of theft, that should be the consequence. If you're cold calling somebody and your intent is to get them to pay money and they happen to be 60 years of age or older, well, you're subject to a penalty for that. there needs to be protection for that. And most of these fraudsters, they have the personal identifying information, so they know who that they're targeting. But I agree that this statute is intended to punish those bad actors who are choosing their victims. I think that's why the crimes that are listed here are specific to those types of crimes and not other felony-related conduct.
Okay, thank you. I appreciate that response. And as always, appreciate you answering all of our questions. I know they are numerous and you have done an excellent job. So with that, unless there are more questions inspired by our questions and questions about questions, we will move on to testimony in support of SB 50. Anybody wishing to give support testimony is invited down to the front here in Carson City or Las Vegas right now. And I see somebody here in Carson City. Please go ahead whenever you're ready.
Good afternoon, Chair Scheibel, Vice Chair Flores, and members of the committee. My name is Jennifer Noble, and I'm testifying on behalf of the Nevada District Attorneys Association in support of Senate Bill 50. We'd like to thank the Attorney General's Office for bringing this important piece of legislation, which will help ensure that greater protections for our most vulnerable Nevadans. Thank you.
Thank you. I don't see anybody else coming down to give support testimony in Carson City or Las Vegas, so we'll go to the phones for support on SB 50.
Thank you, Chair. If you would like to testify in support of Senate Bill 50, please press star 9 to take your place in the queue.
Good afternoon, Chair and Committee. My name is Donna Clontz, spelt D-O-N-N-A-C-L-O-N-T-Z. I'm calling as an individual Nevada senior to support SB 50. I am a former prosecutor myself and prosecuted many thefts in my time, and these days I'm an advocate for the seniors in our community. I think that it's always important to take a look at the crimes that are specifically targeted at our senior population who are vulnerable, especially to these kinds of crimes. And often it's very hard for them to recoup what they've lost because many of them are on fixed incomes and no longer work. So I appreciate the Attorney General's work on this and urge you to vote yes on this bill. Thank you.
Chair, the public line is open and working. However, there are no further callers wishing to testify in support at this time.
All right, then we will move to testimony in opposition to SB 50. Anybody wishing to give opposition testimony is invited down to the front now in Carson City and Las Vegas. I see a couple folks coming down here in Carson City, and I will let you go ahead whenever you're ready.
Good afternoon, Angela. Not from the Washoe County Public Defender's Office, ANGELA-KNOTT. We are in opposition to SB 50. Theft as a charge does not require an intent element as to the victim. That means the defendant does not have to know anything about the victim, who they are, or how old they are. The enhancement should have an intent element. If we are increasing the penalties, talking about more time in prison, then the defendant should be making a conscious choice about going after a vulnerable population. That's what we are missing with theft. The intent of enhancements is to discourage people from targeting someone who is not able to defend themselves or is more prone to victimization. But SB 50 provides no intent. Under NRS 205.0832, theft crimes include receiving stolen property. So you knowingly accept a bike from your friend that they said was stolen in the park, but you don't know who they stole that bike from. Another situation is when a defendant comes into control of lost property without trying to find the true owner, or when a mail is misdelivered to your home and you throw it away instead of taking reasonable efforts to notify the true owner. Both of these would require the elderly enhancement even though you have no idea who the true owner is. Theft does not necessarily include any knowledge of the victim's age or vulnerability, like receiving a stolen bike or throwing away mail or taking a cell phone that was left on a park bench. We believe that there are certain groups of victims that should be protected. NRS 193.1675 provides a mechanism to penalize a defendant for committing a crime because of an actual or perceived characteristic of a victim. But NRS 193.1675 requires the state to prove beyond a reasonable doubt that the person would not have committed that crime but for the existence of such a protected characteristic. Unfortunately, SB 50 does not provide any requirement of knowingly committing the crime of theft because of the victim's age or vulnerability. We would be open to amendments that reflect this type of proof requirement.
Paloma Guerrero, Paloma-Guerrero, Carr County Public Defender's Office, ditto.
All right, I don't see anybody else coming forward to give opposition testimony, so we'll go to the phones, please, for testimony in opposition to SB 50.
Thank you, Chair. If you would like to testify in opposition to Senate Bill 50, please press star 9 to take your place in the queue.
Tanya Brown, TONJABROWN, Advocates for the Inmates and the Innocent. We oppose Senate Bill 50, and we echo the previous comments made today. Thank you.
Chair, the public line is open and working. However, there are no further callers wishing to testify in opposition.
All right, then we'll go to testimony in neutral on SB 50. Anybody wishing to give neutral testimony in person is invited to do so now. I don't see anybody coming forward in Carson City or Las Vegas, so we'll go to the phones for neutral testimony on SB 50.
Thank you, Chair. If you would like to testify in neutral for Senate Bill 50, please press star 9 to take your place in the queue. Chair, the public line is open and working. However, there are no callers wishing to testify in neutral at this time.
All right, then that brings us to the conclusion of testimony, and I'll invite the presenters back up for any closing remarks on SB 50, but it doesn't look like they are going to make any this afternoon. So again, thank you for your presentation. I will close the close the hearing on SB 50, and that brings us to the last item on our agenda for today, which I think is going to be our last item, is public comment. Anybody wishing to give public comment in person here in Carson City or in Las Vegas? I'm not seeing anybody, so we'll go to the phones for public comment.
If you would like to provide public comment, please press star 9 to take your place in the queue.
Tanya Brown, TONJABROWN, Advocates for the Inmates and the Innocent. I just kind of want you to keep in mind of any assembly bills, Senate bills coming your way that this proposed amendment could be put in, or if any of you who will be sitting on the Joint Interim Standing Committee on Judiciary or future 2027 legislative bills, we would like to see what I call Nolan's Law brought forward. It's once a defendant is arrested and charged with a crime, the law enforcement agency must provide the accused defense counsel with a copy of all materiality exculpatory evidence at the same time the prosecution receives it. Then it will be left up to the court to decide what is or is not admissible for trial. Any additional material exculpatory evidence that is provided to the prosecution must be simultaneously provided to the accused defense counsel. There are times when the defense counsel may have it. It is unknown to the accused. And so this is one reason that'll kind of level the playing field. And also Brady violations versus work product. When it is clear that a Brady violation existed, but the court deems to be a work product because of the prosecuting attorney had left his unwritten notes on a court document showing he had defied a court order to turn over the evidence, the notes make it a work product. But in reality, it's really a Brady violation, despite the fact that the evidence was exculpatory. That needs to be strengthened. If it is known that it's a Brady violation because there are notes of saying that he didn't do it, it still should be a Brady violation and not a work product. Because by doing this, everybody could withhold all the evidence, and as long as they put their notes on it and it gets found later on, it's not a Brady violation. That needs to change. Thank you very much and have a wonderful day.
Chair, the public line is open and working. However, there are no further callers wishing to provide public comment at this time.
All right, then that brings us to the conclusion of our meeting for today. Okay, just double checking. We do have a meeting tomorrow, same time, same place, and until then, we are adjourned.